Goodness, take your time.
We're here at the March meeting of the Association of Industrial Real Estate Brokers. Today's topic is navigating the gray matter. We're looking at some of the legal issues that people face when going through the transaction process.
This time I would like to make the announcement for this year's Frank Mahoney Award winner. Corey, do you want to come on up? You're the previous president as well. So this is an event that carries a lot of prestige. A note of thanks to Dan Leahy. This has been a prestigious award brought back by Dan and his knowledge and significant research into the meaning of Frank Mahoney, what he did for the organization, for people all throughout the business. In short, it is a collaborative, mentoring, and cooperative nature that led to this award. We'd like to thank everybody who submitted packages. Everybody was well considered, but this year's award winner, Cawley Dissett. We'll get one outside after this. Congratulations to the new one. Again, that's an outstanding award that hopefully will sit on his desk for many, many years to come. When you have a chance, go up to him and shake his hand.
Listing broker A receives an offer on a property they represent from ABC Supply Company. The deal dies. 8 months later, listing broker B now represents the property, but ABC Supply Company submits a new or updated offer to the former listing broker A. Would the former listing broker A still be paid if they did not submit a protection list upon the listing agreement expiration?
The way I look at that is broker A represented the owner at one time and had a fiduciary relationship to him and knew perhaps what his bottom line was and knew certain things. And now he no longer is contractually obligated, but perhaps legally obligated to not disclose anything that would be detrimental to the owner's position. And I set that up first because at this stage, broker A now becomes a tenant rep and is fully open to be representing the owner, the tenant, and would be the tenant rep, and the new listing agent would represent the owner. The only distinction being that I think he has to disclose to the ABC folks or certain things I can't tell you, although they may have changed. Maybe the owner can take less or won't sell for anything else. But I can't disclose confidential information. That having been said, let's go get it.
I think I agree with Jim, but there is an area of gray here, right? So the original listing broker, how tempted are you going to be not to want to kind of reach out and grab that guy? If he's not being represented by a broker, you would want to still try to make the deal, right? So there's a gray here as to full disclosure with this prospect. I think obviously the right thing to do is to inform ABC Supply that you no longer represent the property. And then the follow-up question is, would you like me to represent you in this transaction?
I would almost go and try to get some kind of waiver or some kind of release from that other party with respect to this before I go forward with this, because they could well raise some ethical concerns with respect to you being the tenant rep now, where you were once representing them as the listing broker.
So you get that from ABC, Jim? Is that what you're saying? From the prospect?
Yeah,
I would have to get that from them.
Yeah. Well, my concern would be that you have. I think Jim really touched upon it. You have information from them that is probably not available to the public, and you could use that information on behalf of the client that you're now repping. And are they gonna raise an issue that you're breaching a fiduciary obligation to me because I disclosed that information to you when you were representing me as the broker on the property?
Legally, does the fiduciary survive the contract? Does its fiduciary relationship survive the contract?
That's a real interesting question. I think at some point, if there's been some disclosure about that property, there may be some fiduciary obligations that would survive the listing agreement.
Listing broker A lists a building that tenant broker B walks ABC Supply Company through. A couple weeks later, ABC Supply Company calls listing broker A directly and arranges a showing. Should listing broker A contact tenant broker B and let them know that their previous client wants to walk back through the space?
Absolutely.
We'll let Cawley go first since he jumped the gun.
Absolutely, for sure. Again, you know, this is, there's professional ethics here, and there's also courtesy, and absolutely. Listing broker A needs to contact the tenant rep broker right away.
I think I'd add one thing to that. I agree that you do let the first guy know. However, you have a contractual fiduciary relationship to the owner, and I think it's critical to disclose and explain the situation to him so that he understands there could be issues that show up down the road that we could probably settle now. And as a result, let him know and then call broker A.
You know, I think we're forgetting, what if the tenant broker was not upholding his obligation to the tenant? And in turn, he may have pissed off the tenant, and so that tenant then decided to call direct. So in that case, you know, Cawley could be correct in stating that you might just have to ask that.
Well, you'd have to ask that of either the party or the broker, but again, you're representing the owner, and if you work for the deal and make sure that you don't impair the deal with issues that are not, that you don't know about right now, move it down the field and cover the bases later. So it makes two metaphors.
Well, we can make this even worse. You know, the broker,
Of course we can.
is saying,
We do usually.
the client is saying, no, he doesn't represent me anymore, but the broker makes a claim that he was the, you know, he introduced him to the property, he was the reason he found the property, and he's the procuring broker with respect to the transaction.
Well, that's why it comes back to our relationships with each other. The first broker is not going to get a dime out of this deal in that case, whether or not ABC buys the building. It's just not going to happen.
Yeah.
On the other hand, if I negotiate with him, stay out of it and I'll give you something, it's something you wouldn't have had, and ABC buys the building and my client sells it. So we can do the right thing, but it's always driven by who do you represent, make sure that they're covered, and then respect each other and do the right thing.
Frankly, this may sound funny coming from a lawyer, but I have found that the brokerage community is as ethical a group of people as I've ever met.
That is funny, actually.
Well, you know, having been around the block, I think you guys do communicate with each other. You understand that it is a small community, and everything Jim has said about this, I think, is very valid. That there's if you want to continue to operate in this community, you are going to act in a certain ethical fashion, because the people that do not work effectively in the community anymore.
Yeah, we have a way of, I'm really proud of my brothers and sisters in this industry, by the way, here in Chicago, and I think that we do a really good job of kind of self-policing each other. You know, there's lots of information that needs to get exchanged back and forth, not just on a single transaction, but as part of our responsibility to our clients, no matter what side of the transaction you're sitting on. So, you know, those folks that cross the line on a regular basis, they don't get that information. You know, they can do that on their own. So we have a really good way, I think, of policing ourselves here.